Welcome to the Kemp IT Law vlog. I'm Nooreen Ajmal, and this vlog looks at a recent decision of the Court of Justice of the EU, or CJEU, on cookies consent. On the 1st of October, the CJEU ruled that consent to cookies cannot be properly achieved by using pre-check tick boxes. The case concerned German company Planet 49 GmbH, which operated an online lottery. To participate, entrants had to enter their name and address and were shown two tick boxes. The first tick box was for consent to receive third-party advertising and was unticked. The second tick box was pre-ticked and was for users to consent to the use of cookies for advertising and analytics purposes. This second tick box was next to a brief description on the purposes of the cookies and the provider of the web analytics. It also explained users could delete cookies at any time. The German Federation of Consumer Organizations claimed the tick boxes did not comply with German law, as transposed from the e-Privacy Directive, and took the matter to the German courts. The German Federal Court of Justice referred certain questions to the CJEU, in particular the question as to whether pre-checked tick boxes are a valid means of getting cookies consent. Unsurprisingly, the CJEU found that pre-tick boxes do not constitute valid consent under the e-Privacy Directive, and such consent must meet the GDPR standards of being freely given, specific, informed, and unambiguous. It held that pre-tick boxes do not demonstrate active behaviour, and it would appear impossible to objectively determine whether a user has given informed consent by not deselecting a pre-ticked box. The CJEU also confirmed that the requirements of the e-Privacy Directive relating to cookies apply regardless of whether the information accessed is personal data or not. The objective of the directive is to protect users against any interference in their private lives, and this includes any information stored on a user's device, whether it is personal or not. The CJEU also held that information on the duration and retention of cookies and on whether or not there is third-party access must be provided to the user so they can properly determine the consequences of having cookies placed on their device. This ties back to the fairness principle of processing personal data and the principle of transparency under Article 13 of the GDPR. The key takeaways from the decision are therefore that cookies consent must comply with GDPR requirements. Namely, consent must be unambiguous and freely given, and so pre-tick boxes won't suffice. Second, users will need to be given information about the duration of cookies and whether or not there is third-party access to cookies. Businesses should review their cookie consent mechanisms and their policies to ensure they are meeting these requirements. If you'd like to find out more about data protection requirements, please check out our blogs, and white papers at kempitlaw.com.